Hello. Good afternoon. Let's get it. Let's get into it. Hello, good afternoon. Let's get into it. Let's answer those questions. Hello, good afternoon. Who's here? Let me know in the comment if you're here. Let me know in the comment if you're here. Let me know in the comment if you are here. Let's get right into it. Let me know in the comment. We're gonna talk about it because the USCIS has updated their website with frequently asked questions about this parole in place for spouses of U.S. citizens. So I want to go over some questions and answer, kind of elaborate a little bit on it, because a lot of questions, you know, we are receiving a lot of questions and we want to be able to help. Let me fix this. Jeez. Okay. Yeah. So we want to be able to help out, okay, and answer those questions to the best of our ability. Let me know if you're here. Just let me know you're here, where you are, what state, and what is your question as I pull up this one. Hold on. Let me share my screen. Okay, let me share my screen. Oh, okay. Almost went blank. You don't need that. Okay. So let me see on Instagram. Anybody here? Okay. Yeah, if you have a question, just let me know, okay? So, process to promote the unity and stability of families, okay? As we know it, on June 18, 2024, the Department of Homeland Security, DHS, announced a key step towards fulfilling President Biden's commitment to promoting family unity in the immigration system, okay? So, what are they going to do? If the person's parole, this non-citizen will generally be able to apply for lawful permanent residence without having to leave the United States and be possessed by a U.S. consulate overseas, okay? An estimate of 500,000 non-citizen spouses could be eligible to access this process. On average, these non-citizens have resided in the United States for at least 23 years. Then approximately 50,000 non-citizen children of the spouses are estimated to be eligible as well, right? So you're a non-citizen, you married U.S. citizen, your child too, really, because you get that. But anyway, your spouse could have applied for your child, but it looks like the child too came illegally, right? So the child has to be under the age of 21. We know that. Okay. Eligibility process, we already know to be considered must be present in the United States without admission or parole. You see the key? Without admission and parole, have been continuously present in the United States for at least 10 years. Okay, as of June 17, 2024, that's the cutoff date. Have a legal marriage to a U.S. citizen, a valid marriage, legally valid marriage to a U.S. citizen as of June 17, 2024. Those are the key provisions, right, to get parole. So now we're gonna go over the questions. Frequently asked question. Question number 1. When will the process start? Okay, USCIS will soon publish. It's going to be published in the Federal Register Notice. That's when we will know when and what form to use. But we already know parole, you use the form I-131 to be parole, right? So the notice will explain what forms to file. As I said, they're gonna tell us what form to file. They're gonna tell us the fees and any required documentation and supporting evidence that will be needed to request parole in place. What you're initially requesting is parole in place, okay? The application process is expected to begin later this summer, okay? So, yeah, now they have a question. What happened if you apply to the US prior to the start date of the process? It's just going to be rejected because you have to wait until later this summer, which summer is starting tomorrow, right? June 21st, July, September, basically by end of almost mid-September, right? Later this summer. We don't know, it might come sooner than that, but what I'm saying here is later this summer. We don't know when. Okay. What will be the duration of parole? What happens when it ends? Well, under this process, a qualifying may be granted parole on a case-by-case basis up to 3 years. During that 3 years, the person will have the opportunity to apply for I-485 or concurrently with I-130, right? And then at the conclusion of the parole, USCIS will anticipate that their individual will have either a pending adjustment of status application or a final adjustment application completed, okay? So that's what they're saying. Application process. Yeah. What are the documents? What can you do to prepare? I've made a video about how to prepare. They have pretty much the same thing I said. Documentation to establish that the non-citizen has been continuously present in the United States for at least 10 years as of June 17, 2024. What type of document? If you have tax returns that can prove that you filed, you know, if you have like a ID, valid ID, state ID, if you have like any letters, let's say from IRS, like TIN number, something that can show pretty much how long you've been here. Sometimes the marriage certificate, because some people got married a long time ago, the marriage certificate itself, it's proof enough to show the 10 years. If you married 10 years ago, right, then that's enough as far as continuous presence is concerned. But if you don't have that, that's when you start looking at your lease agreement, your tax returns, your state ID, medical bills. Maybe you went to the hospitals at some point, you know, medical bills, electricity bills, something that show really this person has been here for that long, with that old date, right? Evidence of a valid marriage, so you're a citizen marriage certificate, evidence of additional favorable discretion factor that applicant would like to USCIS consider. Yeah, this one you might add if you have children with the spouse in question. You might add birth certificate of the children. That just makes this evidence of valid marriage, like bona fide marriage, valid. You know what I mean? And then if the child in question was born 10 years ago, that too, the birth certificate can show, because the name will be there, is going to show that you've been here for more than 10 years, right? You see? Then we go here. Will I need to submit my biometrics? Applicant must submit certain biographic and biometric information to USCIS for the screening and vetting purposes. Will the parole application be available filing online? They're gonna tell us later on. Fees, they're gonna tell us later on what is the fee. Can the fee be waived? Well, they say USCIS provides further guidance about the application process, including fee for individuals seeking parole under this process. Okay, so I guess at this point, really, if you have to pay USCIS fees, it's just better to pay, because remember, adjustment of status, when it comes to adjustment of status, the rule for public charge applies. So you don't want them to show that you can't even, you just don't want that to undermine your application, because, you know, public charge says that you have to be able to show to this government you're not going to be a public charge. And then, you know, when it comes to the green card, you have to apply with the I-864, like sponsorship form from your spouse. So you don't need to be in those filing fees trying to waive it. Don't do that. Okay, so those are the questions related to potential beneficiaries. It says here, I was lawfully admitted to the United States on non-immigrant visa, but overstayed my period of authorized stay. Am I eligible for parole in place under this process? No. If you came with a visa, no. It's just big no. Because if you came with a visa, clearly you are eligible to adjust status because you came with a visa, right? If you marry a U.S. citizen. Unless you came with a crew member type of visa that has its own restrictions. But if you came with a visa, you came legally, that does not apply to you. I got a lot of questions under my last video about, I came with a visa. No, if you came with a visa, it doesn't apply to you because it clearly says here, okay, be present in the United States without admission or parole, you see? So yeah, that's just no. Let's go back to the question. Now we have the removal question. I am in removal proceedings that are pending before an immigration judge. Am I eligible for this process? Who will decide my parole application? You are in removal proceeding, case is pending, but you enter without inspection or parole, and you've met this 10 years requirement thing. So who will decide on your USCIS parole application? Non-citizens in removal proceeding may apply for parole in place under this process before USCIS if they otherwise qualify under this process. USCIS will wait on a case-by-case basis the existence and circumstances of the removal proceedings as well as the applicant positive equities in determining whether to grant parole in place. We are talking about parole in place. We're not talking about the green card application that's gonna come with once you've been paroled in place, right? So parole in place, when somebody's in removal, they will apply the parole in place with USCIS, okay? But then USCIS will look at it case by case basis and see if they can give them parole or not. Okay, they're going to look at the circumstances surrounding your removal proceedings. However, non-citizen who is in removal proceeding because they are enforcement priority. If you're enforcement priority, it means you cannot, they're not going to give it to you. You'll be disqualified. Enforcement priority is like somebody who actually crossed the border legally as of 2020. That person is actually already like disqualified because they haven't been here for 10 years anyway. Another thing is a person is a threat to national security, like people with criminal history, disqualify. Okay, if my parole is pending, can CBP or ICE put me back in removal proceeding or place me in removal? Yes, it depends. Placing someone in removal proceeding is going to depend if the non-citizen is who pose a threat to national security, public safety, or border security. That's what they're doing when it comes to placing people in removal. Okay, if you're not under those three things, then they're not going to place you in removal. Okay, if USCIS deny, am I going to be placed in removal? USCIS maintain discretion, that's on them, but they're just going to go back with this guideline for enforcement of civil immigration law under the Doyle memo. So basically, they're going to look if the person is a national security threat, public safety threat, or border security threat. Okay. Criminal history. All applicants will undergo national security and public safety vetting as part of the process. Okay, they're gonna check the background check and see disqualifying criminal history include criminal convictions that are likely to render the individual statutory ineligible for adjustment of status. The way to know about it, basically, I will refer to TPS. You know that the same crime that disqualifies somebody to get a TPS probably are going to be the same thing that will disqualify someone for parole in place. Because if the thing is going to prevent the person to adjust status because of that particular crime that rendered the person inadmissible, then there's no way they're going to give parole in place. The way to look at it is basically like this, right? This parole in place is only for giving unlawful entry. They pretty much just want to waive that requirement, unlawful entry. After that, then you have to look at adjustment of status. Am I eligible for adjustment of status based on how adjustment of status works? Okay, for example, if you have inadmissibility based on misrepresentation, you're going to need a waiver. We know that. If you have crime involving moral turpitude, you're going to need a waiver. If you have the thing that disqualify from adjustment of status are the same thing that are going to disqualify parole in place, unless it can be waived, right? So just look at it the way you look at TPS. Before TPS get granted, some crimes they just don't give somebody TPS, and some immigration offenses as well prevent a person to get TPS. Okay, can the undocumented child of a non-citizen spouse covered by the policy also be considered for grant parole? Non-citizen children of potential requesters may be considered for parole in place under the process along with their non-citizen parent if the child is physically present in the United States without admission or parole, okay, and qualify as the stepchild. You see, what else? Under the age of 21. And we know stepfathers, that marriage has to be taken place when the child was under the age prior to the child's 18th birthday. Okay, that's to establish the relationship between stepmom and stepdad, step-parent relationship. Employment authorization, basically how long it takes to receive, that's just going to depend, but the person who's granted parole is immediately eligible for AED from USCIS. Then they'll file under category C11. That's it. Go over it. The main thing I hear is if you came with a visa, you are not qualified. If you're in removal proceedings, it's going to be case-by-case basis. Okay? Those are the main things. If you have criminal history too, that's a long story. Okay, let's get it. So let's answer some questions here. Okay, let me get my glasses so I can see those questions. Okay. Mamadou Diaye, what about administrative closed cases? When we look at removal, administrative closed cases meaning the person is in removal. It says that USCIS is going to look at it case-by-case basis. But if you came without inspection, illegal entry, without parole, without inspection, you can file for I-1, like for parole in place, right? But then USCIS is going to look at it case by case to determine the circumstances surrounding your removal proceedings. Then based on that, they will see in other words, you wouldn't know until you apply for it. Then USCIS will tell you whether or not they're going to grant you parole or not. That's what it says. Faith Agape, hi Faith. Mamadou Diaye, if the PP is granted, do you still need to file? And just status with immigration court if your case is a yes. If the PPE is basically just giving you, it's like a waiver. It's just basically waiving that unlawful entry, but you still need to file I-130. The rule of adjustment of status are still the same. The only thing that is basically PPP giving you is the chance to adjust status and forgive your unlawful entry. But the rule of adjustment of status are still the same. You still have to file I-130. Once it's granted, reopen your case, terminate removal, and file the green card, or file the green card with the court, as just depending on how you're gonna recalendar your case if it was administratively closed. You see, the rule of adjustment of status are still the same. Nothing has changed. It's just the fact that parole is basically forgiving unlawful entry. That's all it's doing, and giving a work permit for a period of 3 years until you figure out how you're gonna adjust status. So now we have Taki. Hi, in general, can a prior marriage of my U.S. citizen affect my green card? Divorced years ago. She filed immigration benefit for him. What? Why would that affect? If the person got married, they divorce, then you get married. Well, as long as your marriage is valid, right? And as long as they actually got the divorce is valid, then your marriage should be valid. I don't know what you mean by affecting your case. Yeah, so Taki, T-A-K-I, you have to be a little bit specific. What do you mean by affecting your case? Because the person got divorced long time ago, and they have the right to get married again, remarry. Luz Galinato, we married almost 20 years ago. But what is the question, Luz Galinato? Did you come here without inspection illegally? If you came with a visa, this program does not apply to you. Tishera Linton, hi, what if you have a permanent bar and you're married to an American citizen but living in the United States for 20 years? If you have a permanent bar, that's a different story, right? You have a permanent bar is basically preventing you from adjusting status, right? So yeah, Luz Galinato, if you have inspection, this program does not apply to you. Just move on. This is for people who came without inspection. They're trying to waive that illegal entry for them, you see. Okay, let's answer Tishera Linton. Hi, what if you have a permanent bar? Permanent bar pretty much is it's a bar to adjustment of status, okay? What's going to happen is I-131 was even if, let's just assume I-130 is granted, parole is granted, because we're going to use the form I-131, or maybe they're going to come up with another form, but I know parole, we always use the form I-131. Let's say parole in place is granted, and then you get a work permit for 3 years. Then what are you going to do next? In order to adjust status, you have to be admissible. So if you have a permanent bar, then it's going to prevent you from adjusting status. So that's how I'm going to answer that question. Veronica Villegas, hello, nice to be here. Nice to be here too, Veronica, long time. How are you? By the way, please go ahead and like and share. We got 9 people in the house. Please go ahead and like and share. Hello, cool and Page. You got no patience at all. You know that there are people who have been waiting like for 4 years, right? Then they get their green card. I have a client who waited for 3 years and a half. Okay, and then finally they got their green card. The entire process, I'm talking about the entire process. And finally they got their green card. And as I'm speaking, they are right now home in Kenya. Okay, talking to their family members, their mother. I keep telling her, you need to be patient. You look like you lack patience. Okay, what experience high volume application? Your case is waiting with you. You do not need to do anything at this time. If we need any information from you, we will mail a request for evidence. Okay, it just means that they haven't gotten to your case yet. You just wait. Okay. The only thing, as I said before, the only thing you can do is keep every 30 days, keep filing the inquiry online. That way you're pushing them. And you can go to congressmen as well. So that's the only tools you can use. And meanwhile, you just wait. Your turn will come. Hi, Miss Silly. How are you? How are you? You're welcome, JP. You crack me up sometimes, like, oh Lord, this person is not sleeping. Yeah, you need to. You already done. You almost done basically. With your case, you're almost done. You're just waiting for the decision. Some people are still in removal. We have somebody who filed for reopening the case. They're still in removal in Connecticut. Until today, we haven't got any response from ICE yet. So you are in a better position than that person. That's how you have to see it. So, oh, you're welcome, Miss Silly. So, what else? Yeah, I'm just waiting for questions. If you have a question, just put it. We're just talking about this new program and see how we can answer questions in anticipation. You know, we're still waiting for it to be published in the Federal Register notice. That way people will be allowed to apply to fill out the forms and send it to USCIS with required evidence. Meanwhile, people can just prepare for evidence. That's it. That's all you can do at this point. You're welcome. You're welcome. You're welcome to page. Veronica has a question. What do you think about processing time? In my VAWA, it's been 26 months already. No update, but time is getting. Yeah, Veronica Villegas. Yeah, VAWA is taking too long. What I've seen, at least after 3 years, if it's 26 months already, if you count 3 years, is how many months? Let's see. 36. So in your case, I might say maybe give it another. You might be lucky, right? You never know with USCIS. You might be lucky they might decide your case. But in general, what I've seen with VAWA, when people wait, they wait for 3 years. 3 years. The 39 months, sometimes you don't get to that, but 3 years at least. That's what the 32 months, that's 36 months. That's what people are really waiting. Sometimes 30 months. Oh, you're welcome, Tishera. You're welcome. Thanks. What is the processing time of I-130? I-130, depending on where it goes, right? If you go online right now, let's go online. Yeah, I-130, it's killing me because it's really taking too long. I-130, hold on. Depending on what center, right? And USCIS, are you talking about U.S. citizen spouse? It's showing two. All service center, for example, it's showing 14 months and a half. Okay, but national benefit center, it's showing 38 months for national benefit center, and then when you put all field offices, it's showing 38 to 59 months. Oh my gosh, this is quite. This is no. I don't believe this, because a lot of people will be just filing for lawsuit, because this is too much. Yeah, it's taking too much. I really, it's taking too much. Yeah, let me share my screen again and show you something. Yeah, if you look at here. Oh shit, I'll put it bigger. Yeah, I-130 petition, U.S. citizen filing for spouse, parent, or child. If you go to the all field offices, it's giving 59 months and a half. But all service center is, sorry, 14 months and a half. Okay, but then National Benefit Center is giving 38 months. So we don't know exactly how long it's taking nowadays. But what I've noticed for marriage is not taking too much, unless you get not lucky, like one of my clients. This September is going to be 3 years. That's really unreasonable. I hope they are going to respond anytime soon. Stop sharing. Yeah. You're welcome. You're welcome, Veronica. Yeah, so yeah, I'm just, anybody else? Yeah, if you want to know more about this parole in place for spouses of U.S. citizens, you really have to go on the USCIS website. They did a good job trying to answer questions, frequently asked questions. Um, so you can just go over it. The only thing I know about it is basically in summary, right? In summary, this parole in place is only for giving unlawful entry, right? Entry without inspection. Other than that, if you have inadmissibility issues to get the green card, and those inadmissibility cannot be waived, then you're stuck still, regardless. So that's how you have to look at it, because the rules on getting a green card are not going to change, or they're not going to bend them just because they have this parole in place. That's not how it works. So yeah, we're just waiting for questions. Waiting for some questions before I hang up. Okay, Jasmine Kamour. If you have removal order, can you get Biden parole in place? According to USCIS, yes, you can file for parole. Then USCIS will look at it case by case basis. Okay, but remember, parole in place is something else. Green card too is a different application. So basically, in other words, when you get parole granted, because of removal, you still have to go back, reopen your case, terminate removal, then adjust status. That's just how it works, regardless of parole or not. Parole simply means that they give you the opportunity to adjust status in the United States. They are waiving unlawful entry. That's it. That's all it means. And parole is a different form than the green card form. So people are really getting confused with this whole thing because they think like, oh, I'm in removal, I get parole, I don't need to deal with removal. No, 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 no. That's not how it's gonna. Otherwise, the law has to completely change. This parole, it simply means that they are forgiving unlawful entry. That's all. Unlawful entry, not presence, sorry. Unlawful entry is being forgiven for U.S. citizens' spouses. Once they forgive you your unlawful entry, they grant you parole, permission basically, to get a green card and to apply for a work permit. That the words parole means permission. So if a person is in removal, technically they still have to deal with removal, but you might get granted parole, but you still have to deal with removal in order to get the green card. Okay, I hope you get it. Okay, Isaac said, I wanted to know how parole works in case I wanted to travel. This parole basically is not the travel document. Okay, it's a permission. It's, in other words, you can call it like a waiver. It's a parole. It's a permission to apply for adjustment of status. It's a waiver of unlawful entry. That's how you have to see it. In order to go outside, you have to be granted advance parole to travel outside, and you have to have something pending with USCIS. As far as green cards is pending, then you can ask for advance parole to step out. So those two, don't confuse that. So okay, what are the documents that are acceptable to prove 10 years presence in the United States? Acceptable document has to be official document from some official like government or something like that. Okay, for example, let's say you got married 10 years ago. The marriage certificate itself with your name on it, if it's from 10 years ago, then it shows that you've been here for 10 years. Let's say you had a child who was born 10 years ago. The birth certificate of your child, because your name will be on it, is going to show. If you don't have those like that, then that would be like, let's say you file taxes with your TIN number. You're going to have to show proof of that. And the TIN, like tax identification number, will show. Or if you had some people have social because they apply for asylum, right? Then you're going to show that you've been filing taxes for 10 years ago, since 10 years ago. You can show a medical bill. Maybe you went to the hospital 10 years ago. Maybe you have a state ID. Some people do have state ID without having driver license. It's possible in some states. You might show that. Some people have a lease agreement from 10 years ago. Some people have utility bills from 10 years ago, car title from 10 years ago, like you bought a car here 10 years ago. Anything that is official, yeah. But if you have those big ones that I say, if you got married 10 years ago, that's enough. If you have a child who was born 10 years ago, the birth certificate, that's enough. You have, yeah, I think you got it. Mama Dujai, you have to show 10 years residence until 2024. What they really mean is this, right? They want to see that you've been here. The cutoff date is June 17, 2024. So let's say you've been here in June 2024. June, hold on. Let me see. Let me calculate 10 years. 2014, right? Yeah, let's say you've been here in 2014, since June 2014. Then if you have something from June 2014, that already shows that you've been here. It has to be the 10 years. You count back 10 years prior, prior to June 2024. All right, so what else we have here? I guess we got it now. Because the 10 years really, to be honest with you, Mamadou Diaye, if your child was born, if you have a child, not everybody do, but if you have a child and the child was born 10 years ago, you have a birth certificate of the child, that's enough, because your name will be there. Marriage certificate if it's from 10 years ago. But if you don't have those things, then that's where you go with tax return. You start looking for tax return. You see, like, looking for TIN number, tax identification number, social security, because some people did file asylum before. You can look at notice to appear if you were in removal. Notice to appear is if it's from 10 years ago. Anything that you file with USCIS, if it's from 10 years ago. All those documents, car insurance, title of your car, anything that shows that is from 10 years ago. Is there a way around a permanent bar? Technically, no. Like that, in short, no. Because if somebody has a permanent bar, it means that they're done, right? Permanent bar is something that prevents somebody to do anything. So for example, in some circumstances, if a person has a permanent bar but they're outside of the country, if they spend at least 20 years after, they can try to ask for a waiver, right? But if you're inside the country, it becomes a different thing. So permanent bar for certain offenses, for example, let's say the person has a permanent bar for fraudulent marriage, that cannot be waived. If a person have a permanent bar for falsely claiming U.S. citizenship, it cannot be waived. If a person has a permanent bar for frivolous asylum application claim, it cannot be waived. It's like they're stuck for good. So to go back to your question, is there so to answer your question, is there a way around it? I don't think so. So, but some crime though can be waived. So I'm not sure your permanent bar is based on what. The permanent bar that you're talking about is based on what? Yeah, Linton, we have to know it's based on what, because there are some offenses that cannot be waived, just period. There's nothing you can do about it. So those are the one I just spoke about. Yeah, so we have to know, first of all, your permanent bar is about what. You're welcome, DI, Mamadou DI, you're welcome. Re-entering the country, okay, re-entering the country. I haven't dealt with that. Let me check here. I haven't dealt with that. But what I know in general is that if a person tries to re-enter the country, they have to seek now. So basically, hold on, exception to permanent bar. Yeah, re-enter the country, the way it works. If you have a permanent bar, you have to spend 10 years outside of the country. At least 10 years. If you spend 10 years after that's when you can apply for a waiver, the I-212 permission to re-enter application. If it's granted, then yes, you can re-enter. Some people apply for it even inside as a conditional. It's just depend on case by case, but that's how you can waive. 10 years later, you try with a waiver of permission to reapply. So basically you ask for permission to reapply by filing the form I-212. If it's granted, then yes, discretionary basically for the person who tried to re-enter. I have and I have received a parole, and I second time I've received the prima facie. I have also applied for I-360. Yeah, so what can I do to receive the green? Nothing. You just wait until they're gonna approve it. Right now you're just waiting for I-360 to be approved first. After that one is approved, that's when they're going to yeah, just wait for I-360 to be approved. After I-360 is approved, that's when they're gonna do I-485. Sorry, it's taking at least you have to give it a minimum of three years minimum at least, right? But right now on the processing time online is saying that 39 months and a half for VAWA petitioner. So there's nothing you can do at this point. You just wait for your case to be processed. Yeah, anyway, this is it, right? 48 minutes. 48 minutes. 48 minutes. 48 minutes. We're almost done. Wrapping up. Other questions? Do you have any other additional questions so we can finish this conversation? You're welcome, Linton. You're welcome. Tishera Linton. Thank you very much. So please like, please share. Isaac, Tishera Linton, please like, please share. Mamadou Diaye, please like, please share. Jasmine Kaur, please like, please share. Yeah, everybody, please like, please share. This is it for today, right? I guess we answer all questions. You can go back to USCIS website and read it for yourself. Again, thank you very much. Until next time, bye bye.